Okay, our next topic is get a good retainer agreement. When I collect money for people in the collection practice, and I have these firms, I see that the lawyers from the big firms and from middle-sized firms make a lot of changes and modifications in their retainer agreements. First rule, get a retainer agreement. State bar rules typically require retainer agreements. It is very shocking how many times I get cases from people who don't have written retainer agreements. They have an email, got sued, here's copy, defend me. That's what they have. You need a written retainer agreement. It needs to comply with your state bar rules. Since this presentation is for lawyers all across the country, you're responsible for knowing what your state bar rules are. But you should take a look at what the state bar rules are and make sure your retainer agreement complies with those rules. The retainer agreement should have a provision for how the client protests the bill. There should be some provision that says, if you have any dispute with my bill, you'll bring it to my attention within 30 days of the date I render the bill. A frequent defense in legal fee collections is not legally necessary, overbilled, padded billing, wasn't what I expected, wasn't what I directed, wasn't what they said. And this occurs 2 years down the road when they're looking back through all the bills over the last 2 years and they didn't pay the last bill. Have some provision in the retainer agreement that says you'll look at each bill, and that by getting a bill and sending a check for the bill, you certify or represent that you have examined the bill and that you accept every charge that's on the bill. Avoid the look back. Big firm lawyers, this is for you. In small firms, the lawyer does the work and puts it on the bill. In big firms, an associate or junior partner does the work, and a senior partner looks at it. If you're going to be a two eyes on billing firm where two people look at every document, put that in your retainer agreement. That is one of the biggest sources of disputes later on for non-big clients, for the medium and small size client, where the client says, I never agreed to have two people doing everything. There was no need for two guys doing everything. The top guy could have done it just as good. There's no need to have a junior lawyer doing it and a senior lawyer looking at it to verify that the junior lawyer was doing it right. I'm not in the training business. I'm not going to support your training your associates. Have a provision that says this is our method and technique of how we do it. This is our process. And you understand that this is how we will be billing you.